I would now like to invite Adish Kulkarni, 9th BA LLB, to deliver the keynote address.
Thank you, Gayatri. Good morning and a warm welcome to everyone for this virtual session. Today, as you know, we have with us Mr. Phaneendr B.N, sir, Managing Director and Chief Forensic Expert at CLUE4Evidence Forensic Lab, Bengaluru, who's going to talk on the topic and overview of forensic science and its legal aspects. Before that, let us briefly look at what forensic science is. Forensic science in simple terms can be understood as a systematic investigation of any given situation. To be more precise, it is an application of science in answering the questions which are of legal interest. Forensic science supports criminal and civil investigation by providing expert opinion and scientific information to assist the court in their decisions. Today, forensic science is a versatile and enormously powerful tool in the investigation of crime. It involves the use of multiple disciplines of science such as physics, chemistry, biology, computer science, and even engineering for the purpose of evidence analysis. A crime scene, as we know, have many different kinds of material evidences such as biological samples like blood, urine, saliva, and physical samples like fingerprint, footprint, tire marks, etc. So forensic science involves in collection, preservation, and analysis of such evidence which are suitable for prosecuting an offender in the court of law. There exist various forensic techniques which are used in criminal investigation, such as forensics analysis, DNA profiling, ballistics, forensics odontology, forensics toxicology, and so on. The legal system widely recognizes the role of forensic evidence in the trial of criminal offenders and admits the opinion given by forensic expert, because when a scientific technique or a method is used, there are very less chance of it being a bias or injustice. The application of forensic science thus becomes a very important tool. Today, criminals use advanced tools and techniques to commit their crimes. We may come across many instances of cyber crimes which happen from a remote area and they defraud people. But by the help of this branch of forensic science called as cyber forensics, the offenders can be easily traced. Cyber forensics involves the analysis of evidences found in the computer and digital storage media like pen drives and hard disks. So it becomes easy to connect the dots of the case. Therefore, forensic science uses the same technology which are used by the criminal to identify them and hunt down them. In spite of having such a pivotal role in the criminal investigation system and trial, forensic science is still not known to many, and there is a lack of serious awareness about it. It is probably because of the fact that the entire forensic examination happens at the back end, and the only aspects which come to the forefront are the investigation done by the police and the court trials, because usually they hit the headlines and not the forensic investigation which happens at the back end. Therefore, there is a need for knowing and understanding the various intricacies of the forensic science. Thus, considering the above context, today's session seeks to have an overview of forensic science and its legal aspect. Over to you, sir.
First of all, I thank the organizers for having me here. Second, I would like to thank Priyanka, who gave the introduction about me while I am addressing the audience today. And thirdly, I would like to also thank Mr. Adish for giving an overview of what we all should know at this hour. Because while I actually understand that this forum is the people with a law background, and probably by end of the session, we all will understand how effectively the term forensics has to be used in our legal system, and what is that as advocates and as legal professionals, we all need to prepare ourselves to look at this as a topic before us. So before I proceed ahead, I would like the host to please check the chat box, okay, for further procedure from my side. Okay, while we are in the session of forensics, my dear participants, most of you would have seen, you're very enthusiastic, motivated, and very happy to watch this CBI CID serials. And even in the recent days, there has been many movies which has given good orientation of the term forensics and the application of forensics, including the recent movie Drishyam, okay, part 2. So today we'll be discussing about the overview of the forensics and the legal provisions in our law system as to how the evidences or the term forensics is used, and we also would understand who is an expert. While Vidya Madam has already shared the outline of your course curriculum, which has got different topics which covers in 5 different modules. My role today would be to touch upon all the topics in general and to make you realize the significance of the forensics in our legal system. So I would like to start with my session. So we are going to cover on handwriting and signatures as one of the topic. We're going to touch upon the topic as to who is an expert. We'll talk about forensics, documentary and digital forensics, digital evidences, an overview of that. Lie detection, which is a part of your curriculum, that is a forensic psychology. And if the time permits, we'll also take up some case studies and relevant discussions. So before I start my session, dear participants, I want to share a small instance where one of the businessmen, the top businessman of India, was invited by a top businessman of US for a get-together party happening in Washington, US. So in this party, the businessmen across the world, the top businessmen across the world, were invited for this get-together party. And while the Indian businessman happened to witness the party, he was so happy that the way the party was going on, because that was supposed to be the world's costliest party ever hosted by any businessman in the world. While the get-together was happening, he became very curious. He went and asked the US businessman, hey, how could you be so rich and how could you organize such a grand party? For which the US businessman said, wow, it's a good question. Get into my car. They both sat in the car. The car went for a long drive and the car stopped. And the businessman, US businessman, shows a flyover. Look, that flyover. I had a tender to construct that flyover. So 10% of it unofficially has made me so rich. Matlab, what are the quality I had promised? I compromised 10% so that I became so rich and organized such a costly party to all the businessmen in the world. Wow, good idea. Few months later, the US businessman happened to receive an invitation from Indian businessman, this time inviting him for a get-together party in India. When he came all the way from Washington to India, the moment he landed and the moment he went to the hotel, he is not just surprised, but he's shocked. Are, whatever I did as as a host in Washington is nothing in front of what I can see in the get-together party in India this time. So while the time went on, he went on witnessing the best, and the best till the end of the day. He could not really sit quiet, He went and asked, Ariyar, I'm a US businessman, earns 73 rupees, 73 times costlier than Indian currency. And as a US businessman, if I could not host such a grand party, how could you, an ordinary Indian businessman, happen to host such a grand party? Come on, tell me. The Indian businessman said, get into my car. They both sat in the car. The car went for a long drive, the car stopped. The Indian businessman is trying to explain that flyover. And the US businessman is searching where the flyover is. And Indian businessman says, look, boss, you only had 10% unofficially taken into your account. Rather, I have taken 100% unofficially into my account. Because on document, the flyover exists. Physically, don't ask me anything. The reason why I'm telling you this story is because, it is just a story which is having some kind of reality in our day-to-day operations, because as the professionals in the law industry, or even as a student in the law industry, where you keep on reading the newspaper every day regarding the crime news, there are many such transactions which only exist as per the documents. Okay, and physically there could not be anything which as says exists as per the documents. So with this brief understanding as to how we are going to understand the legality of this forensic application, we are going to have these topics covered today. And I'm touching upon one of the important topics for any advocate or any individual for that matter, which is more often neglected in the real-time application, which is the document forensics. Okay, this again is not in your syllabus, but this is very much required, which I'll be delivering these topics for the Judicial Academy, the Police Academy, and the bar associations of different districts. So this has been one of such topic of their significance, which is highly recommended. That is why I'll be touching upon the document and handwriting forensics also in my topic, and then we'll pass on to other topics of discussion. While I'm going to talk about the documents, so my first question to you all is that what is handwriting? The most expected answer, all right? It is because it is written with the hand, it is called as handwriting, is what people started answering. But it is most expected answer. However, if I have to consider this answer as to because you use your hands to write, this to be called as handwriting. Have you seen people writing like this? They don't use the hand to write. They're using their feet and teeth to write. So what do you call this as? Do you call this as leg writing, feet writing, teeth writing, something like that? No. That means your understanding or our understanding about what is handwriting need to be redefined. Because in general, people use hand to write. It is generally called as handwriting. But technically, it is not called as your handwriting, but it is called as your mind writing. The source, the source of your writing is not your hand. Rather, it is your mind. Hand is just a medium to write. People without the hand can also still write, and still it is called as the mind writing and not as handwriting. While we are discussing about this, and for the reason why the court of law should believe in a handwriting as an evidence or a signature as an evidence. So let me ask you a very honest and very prompt question, dear participants. Is there a possibility of you changing your handwriting? Use the chat box and tell me, can you change your handwriting? Yes. Where have you changed your handwriting? Did you remember recently where you have changed your handwriting? You don't remember. But every test, every exam, what we write, first couple of sheets, we always have a habit of writing as neat as possible. This has been a practice since our childhood days, because we always remember the question paper talking about 5 marks is for neat handwriting. So at least to score 5 marks, even compromising 1 hour of our examination time, we used to write neat and clean of first 2 sheets. And suddenly the first bell goes off. Then you recall, oh my God, I have too much thing to write. So start writing with your normal handwriting sample. And the last bell goes off, last 15 minutes, and you just start writing with the same principle, saying that, look, boss, writing is my responsibility. Understanding is their responsibility. So with this attitude, everybody, including me, I was a student, okay? So including me, we have all practiced the same procedure of writing with a possibility that we can change our handwriting. But if I had to agree that you can change your handwriting, can anyone tell me why does the court of law even today consider the handwriting as one of the best piece of evidence? Doesn't the court know that one can change their handwriting? What do you have to say about this, participants? What do you think? The court does not know or does not believe that the handwriting of a person can be changed? Yes. This is where we all are now going to have the answer for. Because for all the other branches of forensics, there are different limitations, different scope. If I talk about fingerprints, fingerprint is a definite science. Because if I find a fingerprint in a crime scene, the person can be identified as to whom it belongs to. If I get a DNA sample, we can find who the person is. If I get a tire impression, I can find to which manufacturer does a tire belongs to. So all this, the forensic evidences has got different scope and different limitations. While in the field of handwriting evidence or the documentary evidence, what I'm going to discuss right now, handwriting is a part of documents. So handwriting evidence is one of the most criticized evidence before the court, for the reason every time you can write, it has a variation. So for this reason, considering styles such as slant, etc., remains the same. One of the participants has answered. In spite of certain things being the same, not everything will be same. In spite of that, the courts will still rely upon handwriting as a good piece of evidence for which we all need to gather the logical justification of this. Otherwise, we all keep blaming the court. Even after so many years, so many generations of the legal practices, still the court is still adopting some kind of unrealistic and not having any kind of logic where it is relying upon a handwriting piece of evidence. This should be answered by every one of you after this session. So for this reason, the next topic of discussion is going to be, while we just discussed that the handwriting is not just your handwriting, that is your mind writing. On the screen, what you can see, is it the mind or is it the brain? Participants, use the chat box. So what you can see on the screen, is it the mind or is it the brain? So most of you believe it should be the brain and not the mind. So at this point in time, I definitely need to clarify as to what is brain and what is mind. You also have forensic psychology as your topic of discussion. So now you have to answer what is mind and what is brain. I'm waiting for the answer on the chat box. All right, since I don't get any answer, let me go ahead in giving you the answer. The mind is the function of the brain. You cannot see the mind. You can only see the brain. Brain is a hardware and the mind is a software. The brain is a physical organ and the mind is a function of the brain. And I mentioned the handwriting as the mind writing and not the brain writing. Yes, Sarika, you are right. So when we are terming the handwriting to be the mind writing, mind is classified into different categories. What are the classifications of the mind? Mind is classified into conscious mind and subconscious mind. So my question to you, everyone. First of all, does everybody has the mind? So everybody will now answer yes. Okay. How many of you think for every person, both conscious and subconscious mind is present? Do you think both the minds are present for every person? Or are there any instances where only subconscious mind is present for some category of people? For some, it's only conscious mind is present. So I can see yes, but I don't know for what question you are answering it. Okay, so you have to answer yes, both minds for everyone, or conscious mind for everyone, or yes, I got the answer there. While participants mentioned conscious and subconscious both are present for every person, okay, my further question to you is that which mind is bigger and stronger? Whatever the activities you do every day, you mean to say subconscious mind is bigger and stronger? And if you want to give me in mathematical understandings, participants, what is the percentage of subconscious versus conscious mind? Subconscious mind is bigger and stronger. I can even take the proportion of 49-51%. Even that is still considered as subconscious mind is bigger. But what is the actual answer? How big is your subconscious mind compared to your conscious mind? Let me give you a reality and the fact. When Thomas Alva Edison, the great scientist, when he died, the scientists and researchers conducted an experiment on his brain to understand how much percentage of his mind was used. They came out with a very shocking information that the overall, in his entire life, the great scientist Thomas Alva Edison happened to only use 7.2% of his subconscious mind. And with this understanding, can somebody comment about how much big is your subconscious mind when compared to the conscious mind? The results will be definitely shocking. because the subconscious mind is 90% stronger than your conscious mind, which means I mentioned that your handwriting is your mind writing. And when your mind is 90% subconscious and 10% conscious, and when I want to mention that your handwriting is your mind writing and mind writing is 90% subconscious, I want you to write a particular content which I'm going to dictate to you right now. So dear all the participants, please use some writing material, a sheet of paper and with a pen. Be ready with that. Be ready with that. I'm going to give you a dictation, a small paragraph, and let us understand if our handwriting is really subconscious or is there any kind of consciousness in our writing activity. So are you all ready? So I believe you should be ready by now, the pen and the paper. Now, I start the paragraph, go on writing it. In indoor zoo, there was a monkey. In indoor zoo, there was a monkey called Raju. There was a monkey called Raju. This monkey had the habit of throwing bananas at the people coming to the zoo. Looking at this monkey, other two monkeys, Simple and Dimple, also started doing the same thing. I was called to the zoo. To address the issue of the monkeys. Full stop. And you can sign this paragraph 3 times. Put your signature 3 times after the paragraph. Put today's date, 28 September 2021. Also write the place. Done? All right. Participants, now answer my question. If your handwriting was conscious or subconscious, whatever the content you wrote right now, was it conscious or subconscious? Subconscious. What was subconscious, Mr. Akash? In your writing activity, what was subconscious? Okay. People want to comment about what was conscious, what was subconscious in the paragraph, what you wrote right now? That's fine, Akash. Participants, do you want to answer as to what was conscious and what was not conscious or what was subconscious in your writing? What I was writing was conscious, but the way of writing was subconscious. Signature was subconscious, yes. Participants, if you have access to broadcast your video, please broadcast your video and focus on your writing sample. Everyone, please do that. Please broadcast your video and show the writing sample to everyone so we all understand what was conscious and what was subconscious in your writings. Okay. If you observe the writing sample of Gayatri Vijayan, okay, you could understand that the writing, after the writing, the signatures are signed on right hand side. Okay, and the date and the place is also placed on the right hand side after the signature. But when I look at other participants, there are possibilities. Okay, participants, you need to broadcast your video, please. I want to see the writing samples to show how your writing samples can actually show your conscious and subconscious characteristics. Yes, look at different possibilities of writing samples. Look at Nishi, look at Adhish. Okay, yeah, look at Natasha. So I just mentioned to sign your signatures 3 times, but I never mentioned where to sign, how to sign it. Rather, Adhish used to sign one below the other on the right side. Nishi used to sign one after the other, one next to other. And if you look at the size of the writing of Nishi with Adhish, for example, Adhish, can you please confirm, because your writing looks broadly, way bigger than Nishi's writing. So Adhish, can you confirm if you happen to add any extra monkeys in your paragraph?
No, sir, just the 3.
Just the same paragraph you wrote?
Yes, sir.
Okay, Nishi, I believe you did not miss out any of the content while writing. I believe so, yes. So you did not miss out any content. So in spite of that, the same paragraph was given to you. In spite of that, the size of the writing of Nishi and Adish is still varies to a larger extent. Thank you, Adish. Thank you, Nishi. You can now cut short your broadcast. So this was only a simple example that in spite of the content being same, in spite of the timings being the same, in spite of most of you would have used a similar writing material, ruled or unruled respectively, still your writings cannot be the same. And there are good amount of subconscious writing patterns which will come into your writing sample. The one good example is the place where you put your signatures, and also look at your signatures. There are 3 signatures signed by you, and none of the 3 signatures are exactly the same. Just compare the 3 signatures within, one among each other, and I'm sure there must be some variation in all the 3 signatures. And if there is anyone who would say all the 3 signatures are exactly same, that means you are eligible for a Guinness Book of World Record, because there cannot be any possibility that 3 signatures, more than one writing, more than one signature can be exactly the same. You can also verify this with your monkey. You have written the content monkey. Okay, compare the monkey word among each other. The first monkey, second monkey, third monkey in your paragraph, none of the monkeys are the same. I'm sure you definitely have a positive answer for this. So because there cannot be any negative answer for this at all. And the understanding here as to why the handwriting needs to be called as a subconscious writing, and what is subconscious is your style of writing. How you wrote the monkey and the whole paragraph was subconscious, but you are conscious about what is being written. Where is this monkey story coming from? What will be the next statement which I'm going to be writing? That is where your consciousness was. So ultimately, for the writing activity, 90% is subconscious and 10% definitely will have some kind of impact on various factors, which includes some kind of external factors. The pen which you're using it, you're not comfortable writing in the pen. Okay, you might be sitting comfortably, standing uncomfortably. So like all these things, okay, might give you some kind of variation in your writing sample. But because your handwriting is 90% subconscious, the code of law believes and relies upon the handwriting as a good piece of evidence even today. So if there are any possibilities of if anyone can come and say my writing can never change, okay, or all my writings will be exactly same, this is a wrong practice. And even if you try to change your handwriting, can someone answer me how much you can change your handwriting? If in case you want to change your handwriting, how much can you change? Can you change to a certain extent where it can be said it doesn't belong to you at all? Never, because 90% is your subconsciousness and 10% is your consciousness. If you want to bring in any changes in your handwriting, that will be only limited to 10% only. What you know is what, okay, I should be giving you this explanation then. What you know about you is conscious. What you are and what you don't know is your subconscious. There can be many people here who should be thinking about a lot of changes to be brought into your everyday life. Okay, can somebody tell me how much time does it require a conscious activity to become subconscious? Repeated conscious activity becomes subconscious. That is what a good example of your handwriting also. Because on the day one of your learning process in your school, we all were taught to write A, B, C, D. No, we kept on writing. Today we know how to write A, B, C, D. The repeated conscious activity has become subconscious today. But how many days does it require a conscious activity to become subconscious? Any idea, dear participants? Okay, I don't see any question, any answers in the chat box. So I should be giving you this answer. Repeated activity, repeated conscious activity for 21 days. Yes, Shana, you're right. Repeated 21 days of activity consciously will make the activity subconscious. And the subconscious activity, subconscious traits, subconscious strengths are those which you don't even know about yourself. Let me ask you, out of all 115 participants here, are there any athletes, any runners here? People who usually win the running race? Even if I don't have anyone, if I ask everyone the question, how many of you here can run faster than a dog? Can you run faster than a dog? Okay, don't tell me this, but I believe most of you would have been chased by a dog in your lifetime. And the dog is chasing you. Are you not ahead than the dog? You are not competing with the dog, but still you are ahead than the dog when the situation demands. So subconsciously, you have the potential to run faster than a dog, but you have not explored yourself. That is what your conscious belief is. Oh, I cannot run faster than a dog. That is your consciousness. When the situation demands, you have run or you have ran. So that is your subconscious trait. So the simple example of subconscious versus conscious is that whatever you know about yourself, which you may not be, is your consciousness. Whatever you are, which you don't even know about yourself, is your subconsciousness. So for this reason, when you don't even know what is there as a characteristic in your handwriting, how can you change the entire subconscious writing habits? Is a very big question. So it is impossible to change all your subconscious writing habits. For this reason, the court of law believes on the handwriting and signature as a good piece of evidence. However, with this discussion so far, we have answered, can handwriting be used as an evidence? Yes, that's what so far we have discussed. Then, can the handwriting be identified as it belongs to a particular writer? Yes, we are now discussing about the subconscious writing habits, and because of subconscious traits, one can be identified to whom it belongs to. And the third, the question is that, can handwriting reveal the writer's behavioral characteristics? Oh my God, seriously? Participants, how many of you believe that the handwriting reveals the writer's behavior, or do you think it is not actually possible? Please let me know. Because this session is not just about a lecture, because for whatever you want to believe in this, you have to see by yourself. You have to experiment. Okay, that's what the approach is. So is there anyone in this session who thinks that, no, How does the handwriting talks about the person's behavior? Even if there is one person, I'm going to answer this with a demonstration. Otherwise, I'm going to skip this topic. All right. Most of you thinks it reveals. Okay. While most of you did not even answer for this, from how hard they press the whole writing to formation of the letters. Why? Okay. Yes, there are many characteristics which talks about different characteristics. I understand that. Let us do a small experiment, okay, to understand, and let me demonstrate that yes, your handwriting will talk about your behavior. Now you're going to use a fresh sheet of paper. Participants, use a fresh sheet of paper. Do not continue in the same sheet of what you already are writing. Use a fresh sheet of paper. And everyone will do this activity because I'm going to ask you to show me the activity after this activity is completed. Okay? So now on the screen you have the instructions. So you're going to draw a peg. Draw a peg head to toe. This goes with the understanding that your friends mentioned anything written by the hand is handwriting, and we are now discussing about the handwriting talking about your personality. So for this reason, go ahead and draw a pig. And for all the Muslim friends here, you can draw a cat if your pig talks about your personality or not. If in case your pig is written on the top part of the paper, if in case your pig is written on the top part of the paper, these people are optimistic and they are very positive people. They think positively. That means the paper, if you have observed your pig, it should be on the top part of the paper. On a second option, if the pig is on the middle, that is mid part of the paper, these people are realistic and very practical people. They want to see everything in black and white. Okay, but for the first person, they are optimistic. Or if not today, we'll see have something tomorrow. But for the middle people, they want to be seeing everything in black and white, realistic people. The third, the people may behave negatively, negative thinkers. They first think about negative, then they come to the positive side of your thoughts. Okay, the next understanding, if the pig is facing to the left margin, that is left side of the writer, these people believe in tradition and they are friendly and they tend to remember the dates very easily. Birthdays, anniversaries, the first meeting day, all these things these people don't forget. Whereas, on the contrary, the pig facing to the right side, these people are innovative, they are very creative, but they don't have a strong sense of family, and given a task, they forget the whole world. So for this reason, don't expect the people who are riding the pig facing right side to wish you on your birthdays, anniversaries, and they don't usually often remember the dates. So don't expect that from them. Third, the 3D effect pig, most of you have written that. Okay, the 3D effect pig talks about you are direct, you enjoy playing the role of a devil's advocate, you neither fear or avoid discussions, it actually arguments. You don't fear or avoid arguments, you argue for the sake of arguing, even if you might be wrong. Okay, that is what this pig facing to you directly talks about. Next, a lot of information in the pig. These people are analytical, cautious, and they don't trust others easily. A lot of information includes 4 legs, 2 eyes, 2 ears, the tail, everything, clearly visible. Not much of information. That means these people are emotional. They care for small little information, but they may be a risk taker because they are emotional. They don't go with logic. Next, 4 legs and 2 eyes visible. Don't tell me it's on the other side. It should be visible to you. In that case, you are secure, you're stubborn, and you stick to your ideas and ideals, even if you are wrong, you don't want to change your decision just because of others. All right. Next, bigger the ears, better listener you are, and you're also attentive to details. And there are many who would actually have forgotten to write the year. Okay. Next. This is what my pig is, but however, did we miss out anything from the pig analysis, dear participants, or did we cover all the aspects of the pig? Is there anyone who would like to know if anything is missed out? Use the chat box, please. Okay. Did we cover all the aspects of the pig? What if only 3 legs can be visible? You are not so stubborn. Next. Observe the pig carefully and tell me if we covered all the aspects of the pig, or is there anything which we left out, dear participants? Writing pig in caps or small depicts anything? No, nothing for this activity right now. People are now getting this understanding. What about the tail? Participants, tail is the climax of the pig story actually. Okay, so when you're so curious to know what the tail talks about, I want to show you what the tail talks about. On the screen is its explanation. Longer the tail, stronger your sexual drives. My God, first thing I said, positive thinkers. Everybody are happy actually. Hey, look, I'm a positive person. I'm very happy. I'm a positive person. And now I'm talking about the tail, and people are now verifying how big their tails are. Fine. The sexual drives is a psychological terminology which is often used to refer the physical energy of the person. Okay, sexual drives is not about the sexual activity. It is about your physical energy of the person. So these people often like traveling, sports, exercise, games, gymming. So these are those people who usually write the tail longer, is what the understanding is. Now, participants, tell me what is the accuracy of the pig analysis? How much percentage of the explanation was accurate to your personality? Please comment on the chat box. Out of 100%, how much percentage was pig analysis accurate? 100%. Gayatri Vijayan must be so generous. Okay, and I thank for 100%. But I want to know the least number from this activity, dear participants. 95. Okay, while I consider CMR is more generous people, even if I want to consider the activity of the pig analysis can give me a 30% accuracy. I am talking about the least possibility, a 30% accuracy. Participants, you don't write pig every day, but if pig can talk about 30% of your personality, you write the handwriting every day. That has got more information about you as a person. So for this reason, yes, your handwriting definitely talks about your personality. Very simple explanation of forensics, which is very relevant for law students here. I would like to explain the term forensics like this. Number 4 and number 6, 4 and 6. The result of 4 and 6 will be the numeric 10, 1 and 0. In our binary system, 1 is always given a truth value, 0 is always given a false value. So I believe the science students, if anybody are here, you will understand the gates, the electronics and electricals. So 1 is always a truth value, 0 is always given as a false value. The ultimate scope of forensics is to conclude if the given claim is true or a given claim is false. Last 3 days on the media, we are discussing about a cracker being bursted, causing the death of 3 people. So with this question, after the analysis, the claim is that cracker bursted and 3 people died in Bengaluru. So after the forensic examination, people will confirm if that claim is true or no, that claim is false. And what is the actual fact? They want to bring it in. So ultimately, whoever gets the claim, whoever brings in a particular claim, the ultimate scope of forensics is to ascertain if the claim is true or a claim is false with suitable logical, technical, justifications as a part of the requirement is concerned. So that is a simple explanation of forensics. Apart from what you can see in the textbooks as an explanation, forensics is a branch of science which usually deals with the investigation aspects and the legal requirements. Today, and forensics is not necessarily a science subject. Forensic science is a logical approach, is what we should be understanding. Because today we also have forensic accounting, forensic auditing, forensic linguistics. Linguistics is an art subject. Accounting is a commerce subject. That is not science subject. But still, we have forensics in those subjects. That is to be understood as forensic is a systematic approach, a logical approach for establishing a particular theory along with supporting facts. That is a simple understanding about the term forensics. Now, while on the screen, dear participants, for all those who are using the computer screen, which is a bigger screen, they can actually answer this well. And this actually might not be so relevant for people who are using it on the mobile screen, dear participants. But however, looking at the diagram on the screen, can you people comment if the line AE or the line EC, which of these 2 lines is lengthier? Which of these 2 lines appear to be lengthier just by looking at it? Please comment on chat box. AE. Okay. All right. Thank you. Thank you. However, for all those who are using the computer screen, now can you please help me to actually measure the line AE versus the line EC? You can use a scale or a piece of paper just to understand how long the line is showing on your screen. Can you reconfirm if the line AE or the line EC, which of these lines is lengthier after measuring it? Please do that. Sarika Venkatesh, did you measure this line on the screen? Sarika Venkatesh. EC is now lengthier. Chinmaya, probably you're using a mobile screen. That is why it appears very small. So that's why I said not to use it. Yes. So the screen size will actually comment about it. But however, actually speaking, line EC is lengthier than the line AE. Nishi, I am waiting for your measurement of EC. Yes, correct. So on Nishi's screen, line AE measures 4.5 and line EC measures 5.5. But for all the participants, just by looking at it, you felt line AE is actually lengthier. However, the question before us right now, okay, is that whatever you see can't just be believed. What you see can't just be believed. To give you another example of this, participants, you can see a black dot on your screen. I would ask you to put the screen and go far, around 5 feet from the computer screen or the mobile screen. Take 5 feet gap, go back, okay, and use your arm like this, open your arm, use your index finger and focus on the black dot, close your left eye and focus on the black dot. Go back 5 feet and open your arm using index finger, focus on the black dot, close your left eye and hold on. And now open your left eye and close your right eye. Are you still focusing on the black dot? No? Okay. So is the black dot moving? Okay. I'm not using any graphics on the screen. Blackboard is not moving, okay, but this activity is a example or a demonstration that your eyes can cheat you or our eyes can cheat us. The scope of forensics is not just to comment about what we see. It's more about going deep about the finding the reason why is it moving. It is not moving literally. It appears to be moving because of your eyesight, but to find the logic as to why is it moving is forensics. To go beyond what is seen and with the understanding that we cannot trust our own eyes. We have to only go with the technical and logical explanation before the forensic examination. That is the purpose of this activity, dear participants. Now, while I believe the concept of forensics is set, okay, the question before us is it's a bigger stake question actually. This is $1 million question in most of the cases. Who is an expert? Can somebody who is in 7th semester or the 3 years course, who are in the last year of the course, comment about the Evidence Act and tell me who is an expert? Anybody want to comment about who is an expert? Let's forget about Evidence Act for the time being. In literal sense, in using common sense, whom do you consider an expert in any given field? I'm not talking about forensic expert here. I'm talking about just an expert. Whom do you consider an expert? Give me your answers. And participants, I recommend that you can use your microphone, unmute your microphone to answer this question because that will be fast and that will be more interactive. While I still found some answers, who is specialized in something, who has knowledge and experience about the subject, someone with a lot of experience. Okay, Abhishek, if I have to consider someone with a lot of experience, a compounder who is the attendant of a doctor. When you go to a doctor's shop, doctor is busy and the compounder will come and give you a tablet. Look, boss, doctor is busy. You take this tablet and you'll be fine. Do you consider him as an expert because he might have 20 years of experience as the attendant of the doctor? Abhishek Agarwal? He is an expert in his own self, in his own field. But you're going to a doctor. You're sick, okay, and you're going to the hospital. And at the entrance of the hospital, if the attendant will give you a solution, do you consider him as an expert and would you go home? You will not take that medicine because in that case, your explanation that his a lot of experience should be called as an expert is now his question. Now, going to other explanation. A person who has studied the subject in detail. Okay. How many of you have watched the movie Catch Me If You Can? A person in this movie studies every subject. Okay. And he studies not having a proper academic degree, not having a valid certificate. Still, he studies the subject. He becomes a doctor, he becomes a lawyer, he becomes a pilot, okay? And he becomes all those things by studying the books and acting as that person. Okay, here, he does not have an academic degree. Still, do you consider him as an expert? No. Next, a person, someone with a lot of experience, gone. Person who has studied the subject is gone. Someone who has a knowledge and experience about the subject, yes. Now, this is a relevant topic to discuss. A person who is to be called an expert as an expert should have knowledge and experience about the subject. What is knowledge? Knowledge is the combination of your academic certificate with the skill. And what is skill? What is skill? So if you have just a certificate, suppose you go to the jungle and you are attacked by the tiger, okay, and you want to show the certificate, look boss, I have a gun license certificate, or you should know how to use the gun. This is the difference between what is a qualification and what is a skill. An expert should be having both. He should be having the knowledge in such a way he is qualified to have the weapon, plus he knows how to use the weapon. So that makes him an expert in the legal explanation. However, Section 45 of Indian Evidence Act, and in our entire legal dictionary, there are only 4 sections so far. In the entire law books, there are only 4 sections which talks about the experts, the term experts. One is Section 293 of CRPC. Next is Section 45 of Indian Evidence Act. I have missed out that word here, Indian Evidence Act. Section 45A of Indian Evidence Act plus Section 79A of Information Technology Act. So these are the 4 provisions which explicitly talks about who is an expert and what is the provisions of the experts. Let us now read what does Section 293 CRPC talk about. And the question also arises, does our law limit the use of forensics in the legal procedure? If this question is to be answered, Section 293 CRPC talks about reports of certain government forensic experts. So this says any such document purporting to be a report under the hand of a government scientific expert, which means that we have, every state has got forensic science laboratories, and today morning news is that Karnataka Chief Minister proposes 6 new FSLs across Karnataka state. Okay, we had only one state forensic science laboratory in Bengaluru, and otherwise we only had RFSLs, regional forensic science laboratories, which only has limited functioning of the domains. Not every lab will have toxicology division, not every laboratory will have a cyber division, something like that. The limited sections what they had given. Today they propose to have 6 state forensic science laboratories across the state of Karnataka. Different states might have different provisions. UP has proposed for 18 FSLs across UP state. So like this, any report given by government scientific expert, this section specifically applies to them. And whom this section applies upon any matter of thing duly submitted for him for examination or analysis, and report in the course of any proceeding under this code, please understand now, may be used as an evidence. It does not mention shall be used as an evidence. It is may be used as an evidence or in an inquiry, trial, or other proceedings under this code. So now tell me, the provision that it may be used as an evidence, is it not an actual limitation of using the forensics in the legal system, dear participants? What was the limitation? What was the hindrance we had to use the word shall be used? Can somebody comment about this? Why did our lawmakers use the term may be used as an evidence and did not use shall be used as an evidence? Okay. For this, you should refer one of the important case law, dear participants. It's very unfortunate case law, however, but still it is very important for you to understand the gap of forensic science which can actually impact the legal decisions. The case law is Dhananjay Chatterjee versus State of West Bengal. Please make a note. It is called as, famously called as Dhana's case. It's Dhananjay Chatterjee versus State of West Bengal. Please refer to the chat box. I've given the case name over there. However, let me, it's very useful if you want to go through the judgment of Supreme Court in this particular case. But let me give you a brief of this particular case. The girl who was residing in her apartment was teased by the security of the apartment. The apartment was called as Alasha Apartments, and he happened to tease the girl while she was going to school and coming back. She complained this to the father. Father happened to raise a complaint with the security officer, and security officer happened to transfer this security guard to some other apartment during early 1990s. This case is of early 1990s, where you did not have any kind of mobile phone, internet, nothing like that. Okay, fine. The next day, still the security guard reports to the same apartment. 2 o'clock, the girl comes back from her school after the exam. She has her lunch, she sleeps. At 5 o'clock the same day, it was a Thursday, 5 o'clock, the mother has a fixed schedule on Thursdays. She wants to go to temple on every Thursday. By 5:15, the mother leaves house, and by 5:40, she's going to come back on her visit. So there's only window gap of 20 minutes. Now, after the mother left house, this security guard happened to take the lift to go to the first floor where the girl's house was there. And the lift operator has seen him going to the first floor. However, by 5:15, 5:25, the security officer comes to the apartment and he realizes by another security guard saying that Mr. Dhananjay Chatterjee still is in the same premises, but he has not reported to any other apartment where he was transferred to. And he calls Mr. Dhananjay from the ground floor because it was a ground floor. He was on the first floor. He saw, okay, are you calling me? Okay, I'm coming, wait. He comes back and he did not talk to the security officer. Okay, because the moment he comes down, he says, I want to go home, and he left the place. By 5:30, 5:40, the mother comes back and realizes the door is locked from inside. After several attempts, the girl did not open the door. The neighbors started getting panicked because the girl came back from the examination. It is a possibility that she has not done well in the exams and she would have attempted to commit suicide. So for this reason, the neighbors had called the doctors by then, and people also broke open the door. And the moment they went inside, the mother saw the girl lying in a pool of blood, murdered. So she happened to be lifted and took to the lift for medical treatment. At the time, doctor reported over there and declared the girl as dead. With this background, dear participants, now tell me who is the murderer. It was a rape and murder of a minor girl. Okay, now tell me who is the murderer in this case. Participants, I am waiting for your answer because I want you to really comment about this instance, because this was the only information available before the investigation officers, okay, for arresting some people or arresting a person or considering the person as guilty of this offense. Whom do you think is the murderer in this case? Circumstantial evidence points towards Dhananjay. Very good. This case is a case law for circumstantial evidence. This was, however, Akash Kumar, let me also give you one more information. The report of Assistant Chemical Examiner of the Forensic Laboratory, West Bengal, happened to be reporting saying that on the girl's pubic hair, there was a presence of semen. Semen is a biological fluid of a man. Okay, and if the semen is present on the girl's pubic hair, to whom this semen belongs to, can you not identify? We can definitely identify to whom the semen belongs to, because that's a DNA evidence or a biological evidence. But the assistant examiner's report stated that this semen does not belong to Dhananjay Chatterjee. In spite of that, this case was convicted for death penalty of Dhananjay Chatterjee. That's why I mentioned it was a very unfortunate case. This case goes against our legal jurisprudence, which says even if 100 of criminals are let off, one innocent should not be convicted, right? That is our jurisprudence. And this could be one of such case. It's not that I'm criticizing the judgment of Supreme Court, but it's a question before the legal fraternity on how this particular piece of evidence was not considered by Supreme Court of India, and the aspect of the Supreme Court or any legal court for that matter, it must be a case to be proved beyond the reasonable doubts. This case was not proved beyond the reasonable doubts because there is a doubt as to whom the semen belongs to. The semen doesn't belong to the convicted person right now. So for this understanding, you need to go with this provision. It may be considered as an evidence. The reports of the certain government experts may be considered as an evidence, which only gives the court that provision to either consider or not to consider this kind of forensic reports, provided if the forensic reports does not go along with the circumstances of the case, the court need not rely upon even the technical evidence, is what the case law as well as this provision says. It is good that we have the provision of may be used as an evidence. It also gives a provision to the court not to consider any evidence which doesn't have a technical validity. Okay, so for this reason, any report given by any expert should be legally and technically to be supported. That is one provision. But apart from that, in spite of that attempt also, if that report is not getting along with the circumstances of the case, the court still does not have any obligation to consider the forensic evidences. And this is the understanding of the forensics on how the forensic evidences can actually impact our legal decisions. Okay, going further, dear participants, I would like to skip the provision of section 45 because it's very simple to be understood. Any person who is skilled in a foreign science or a foreign art is to be considered as an expert. This section does not comment anything about the qualification. It talks about the skill. Any person who has a skill in a foreign law or a foreign science, because Indian Evidence Act was enacted in 1872. At that time, there was no universities, there was no schools which offered forensic science or any courses on handwriting and fingerprint examinations. So at that time, these two sections were to be considered as a skill only. So for this reason, even today, we still adopt the section 45 of Indian Evidence Act, which talks about any person who is skilled in a foreign science or a foreign art is to be called as an expert. 65B. Okay, this is 65B again of Indian Evidence Act, talks about authentication of electronic evidences. Okay, today, in the recent days also, Supreme Court held that WhatsApp data cannot be used as evidence. Okay, but you have to look at the whole judgment very carefully, dear participants, because the people and the media, they misinterpret, okay, the whole judgments. It was also misinterpreted, and we all have seen the WhatsApp forwards in the earlier of 2020. It said Supreme Court has made legal adultery as legal. Okay, you all were a part of this discussion. If I'm not wrong, you would have witnessed this WhatsApp forwards. Supreme Court has made the adultery legal. Did it really make the adultery legal? No. So like that, Supreme Court today held that WhatsApp data cannot be used as an evidence. It goes to say that anything which is not 65B authenticated need not be relied upon. 65B is a special provision for authenticating of the electronic evidence, which includes today our email communication, computer evidence, mobile evidence, CCTV evidence, everything comes under the electronic evidence. So for this particular provision, 65B certificate, so 65B authentication is what the detailed provision what our lawmakers have given. Please read 65B of Indian Evidence Act, which is very in detail mentioned as to who can issue a certificate of 65B, when it should be issued. So it is very much detailed explained. Now, touching upon one of the topic of your syllabus, that is the Selvi versus State of Karnataka is a case law. However, the topic comes under the lie detection and the polygraph evidence. Tell me something, is today lie detection evidence, the polygraph evidence, admissible before the court? Participants? The polygraph evidence, polygraph report, is it considered as an evidence before the court today? No idea? Okay. As corroborative evidence? No. Literally speaking, polygraph reports is not considered as evidence at all before the court. And for this is a case law, Selvi versus State of Karnataka, where it's a beautiful piece of judgment. And for you to understand all the aspects of lie detection and different techniques, okay, you just have to read this judgment. You don't have to read any textbooks, because the textbook itself is made as a judgment in this case. Beautifully explained by Justice Balakrishnan sir. He has mentioned, I mean, this judgment goes on to mention different techniques available for lie detection, different techniques and their limitations, different kinds of questions, what we use for the lie detection, the legal admissibility, National Human Rights Commission's guidelines. Everything is mentioned in this particular judgment. And this, because of this judgment, the polygraph evidence is not considered as evidence in India. However, if you ask me, is polygraph result not conclusive? Technically, I would say it is definitely conclusive. And we should also understand the limitation of the lie detection. It is said it is the lie detection test and not truth detection test. Why is it called as lie detection? Because it is a limitation while I conduct the examination. Say, for example, I'm going to ask Ayusha, Ayusha, is your name Ayusha? And she says no. Okay, and suppose on a contrary, I'm going to ask Ayusha, is your name Tanisha? And Ayusha says yes. I can see she is lying. Okay, but I can only say she's lying to me, but I cannot say what her actual name is. Okay, I'll have to do a test again. Matlab, is your name Ayushi? Okay, she says yes again. Again, I see it's a lie. No, again, she is not Ayushi. Okay, I'm going to ask 100 different questions. I can only say you are lying to me. But because of this lie, I cannot say what is the truth. So for this reason, the lie detection can only be used as a good investigation tool, effective investigation tool for the investigators. However, the report that you are lying in the test of lie detection test, it alone cannot be used as a evidence, and you cannot be convicted because you are lying to the lie detection test. However, based on this judgment, it says this judgment is a case law of our constitutional provision. Okay, 20 subclause 3, Article 23. It says no one can be compelled to be witness of their own cause. So in the lie detection, what are the statements you are giving? That statements are held against you for the purpose of conviction. So for that reason, this polygraph test results are not considered legal, but polygraph is technically correct. Legally, it is not adopted in India, but all the CSI, FBI agents across different investigation departments, they will undergo a polygraph test every 3 months, every 2 months, and they will have to, they'll be checked with their loyalty. Are they our agents or are they acting as double agents? Every investigation agency will keep doing this test. So for this reason, the lie detection tests are technically very conclusive, very correct, but because of this judgment, it says no one should be compelled to be their witness of their own cause. So the results of the polygraph tests are not considered as evidence before the court of law, but because you are lying to me, I'll further investigate. I found some other evidence. So that evidence is a good piece of evidence in the trial. Because you lied to me, I further investigated, and that is a good evidence. And this evidence, this report that you are lying to me is not alone a good piece of evidence, is what this case law has tried to educate us. And predictable investigators. Whatever the lapses any investigator would have done in their course of action, when the advocate is playing the role effectively as advocates, they are the best investigators. And when they know the aspects of investigation, they would definitely bring the truth out before the court of law. It is not important that the police officer should be doing a proper investigation, but it is very important that the advocate should know the aspects of the investigation and to question as to what should have been the investigation. And during the course of cross-examination, you can still do a proper investigation of your case. So with this small idea, so on the screen, you have a case. The question in this case was if the signature on the top part of the check is forged or not. Remember that there are two signatures, one on the signatory is the space, another on the date column, close to the date column. So now tell me if this signature is forged or not. And in this case, there was also a question, if the date is altered or not. This was a question. So now answer my question about your views as to what do you think about the case. Is the signature forged? The signature appears to be forged because the writing slant. Okay, signature is forged. Okay, date is also altered. Okay. Okay, let me give you the further close-up image of this signature. Yes, however, let me give you the signature on the top part of the signature, top part of the check is actually not forged, because there is a possibility that if in case you're signing your signature in a small space which is given to you, you like to compress the size of the signature and still write your signature, which might actually look different on a prima facie. But when you look at the characteristics a bit closely, all the characteristics what is present in the lower part of the signature is also same as the upper part of the signature. When I realized the signature is not forged, then when the question was about the ink, observe the alteration of the ink. What is altered to what? What is altered to what? Yes, Gayatri mentions that the general rule that the altered checks cannot be honored. It is true, but this particular check belongs to the date before this rule was practiced. Earlier, the checks, whatever the corrections are there, you make a correction, do another attestation with your signature, still the checks used to be passed. Okay, 3 or 5 is altered as 8. Observe carefully. First of all, the check was given in the year, in the dated 200. 3 was the last digit, and the 3 was made as 4. Because 3 was made as 4, the person signed it. That is why the signature there is not forged. However, the person who received the check in the year 2008, because 3 was already there, one part of the 8 was already there, he altered the 3 as numeric 8. That is why you can see the 8 left part with a different ink and the other part with a different ink. However, the ink which is used on the left side of the numeric 8 is as same as the red underlined the content on the check. Please observe that. The green underline is one ink and the red underline is another ink. And further, you can see what is the reality. Look at this. The check was only given for 5,000. 7 is added later on to make it look like 75,000. And you have a question now, how did they write in words 75,000? The check was given The check only had the content, signature, okay, the amount 5,000 and the date 30th/4/2003, corrected as 4 and signature. Only it was there. And Bhagyamma and 75,000 was not there when the check was issued. But the person who received the check made as 8 wrote Bhagyamma and 75,000 only. So for this reason, the green underline is a different ink and the red underline is a different ink. When you ask me, what is the significance of 416 in this case? Yes, before the court of Mysore, this was a court document. You can also see the court seal at the lower part, JMFC. So this case, the question was only about signature, if it is forged or not, and the date is altered or not. One party claimed signature is not forged. Another party claimed the date is altered. Actually speaking, this report did not favor both the parties. Why? Because signature is not forged. One party's claim is nullified. Other party's claim was date was altered. Yes, the date was altered for genuine reasons plus a fraudulent reason. So ultimately, so far the question 75,000 was not even questioned. Both the parties thought the check was given for 75,000, but it was only the forensic report which said 5,000 was a different thing and 7 was a different thing. Then the issuing person realized, yeah, there could be a possibility that I only given for 5,000, and this case was settled outside the court because the report of forensics did not favor either of the parties, and it only brought the truth before the court. On the screen, I think it's the last case which I'm discussing, or second case which I'm discussing. Okay, look at the screen. I know most of you don't read Kannada. The script is in Kannada, but apart from the Kannada as a language, what do you find as suspicious in this case? Is there anything suspicious in this case? Abhishek, I'll answer your question very soon. Okay, I'm waiting for the inputs of this particular case. Last part added later. Yes, it looks like. But just because last part looks like being added, can I say the document is fraudulent? The document looks suspicious, but it is not. It cannot be concluded as a fraudulent. See, being suspicious and being fraudulent, both are two different things. All right. But however, in a photocopy document, we were asked to examine the signatures. In the bracket or the second image, you can see the Urdu signature is actually marked. I was given to examine the Urdu signature if it is a forgery or not. But in the legal system, for a handing expert to comment about the signature will actually kill 1 year time for the litigants. Why? The application for referring the handing expert, appointment of the commissioner, examination. After we submit the report, objections, based on the objections, order will be passed. Based on the order, a cross-examination will be conducted, and cross-examination might be conducted in the same day, or it might be extended for 1, 2, 3 days. After that, there will be an argument. Okay, why and why not the handing expert report is to be considered as an evidence or not. And based on this argument, there will be an order. Yes, this will be considered as evidence, or this will be dismissed as a report. So this entire duration will take at least 1 year for the litigants. So this case was not of handwriting significance, though this was a question document. So the ultimate thing what you should be looking at in this case was, I only filed a REI application, right to information application. Look at the rubber stamps. This is a stamp paper. Okay, stamp paper value of 5 rupees. On the rear side of the stamp paper, there will be a government seal along with the stamp vendor's seal. Okay, when will this person sell the stamp paper? Everything will be there. So this stamp paper was sold by the stamp vendor to the particular person who signed the document. on 11th June 1974. However, this stamp vendor has bought the stamp paper from the government treasury on 9th June 1974. But for his unfortunate reasons, 9th June 1974 is a Sunday. So there cannot be any stamp paper transaction which could have happened on a Sunday. So for this reason, what I applied was just a RTI application to the government of Karnataka State Stamps and Registration Department to give me the transactional details of all the transactions which happened on Sunday in past 50 years. And they gave me a reply saying that no transaction have ever happened on any Sundays in past 50 years. Only based on this RTI response, this case was actually dismissed by the Honorable Court in Devanhalli. So what I mean to say here is that not in all the cases you require a forensic expert. Forensics is to a certain extent more of common sense, a logical justification. In some cases, you need an expert. While Abhishek has recommended in the previous case that signature, when the signature was questioned, the signature opinion was required by the court. Yes, the handing expert's opinion, that was me, who gave the opinion in this case, that signature did not was not forged. Both the signatures were signed by the same person. The angle at the end characters looks different because the space available to sign is much more than the space which has a constraint at the top part of the signature. So for this reason, along with all the justifications, this was said and given as a report by the handwriting expert only. In addition to that report, in addition to that observation, the information that 5,000 was altered as 75,000 was also included in the report is what I mentioned. Yes. So with this, dear participants, I am concluding my topic at this hour. So, while I have concluded my session, if in case you have any questions, you can ask. Otherwise, over to the host for further proceedings. Thank you very much.
Thank you, sir. If anyone has any questions, you may place them in the chat box.
In the meanwhile, I am also going to share one of the important link for you all. I have shared one of the link, CLUE4Evidence.org/internship, and we offer exclusive internship for the law students based on the forensic topics. So we have both online and offline internship. Based on your interest, you can take part in that.
Since there are no questions. Yes, sir. Thank you so much, sir, for such an informative talk, sir. It was, in fact, a very great session. We really enjoyed it. Now I would like to invite Adish to deliver the vote of thanks.
Thank you, Gayatri. It is indeed my privilege to be delivering the vote of thanks to all those people who are involved in making this webinar a success. I would first of all like to thank our guest speaker, Mr. Phaneendra B.N, sir, for giving us an insightful lecture on forensic science and its legal aspects. Thank you so much, sir, for that fun-filled, knowledge-enriching and inspiring session. We thoroughly enjoyed the case studies and also the real-life instances which you put upon. We are sure that we have completely understood that the forensics is not about of the prima facie what we see and not what we get it by the face value of it, but it is much deeper and much more important than it looks. And we couldn't notice the passage of time, and it was completely enjoying. Thank you so much once again, sir. I would further like to thank our respected Dean, Dr. T.R. Subramania, sir, without whom this program wouldn't have been possible. Sir has always supported us in all our endeavors and has been constantly organizing such events for the betterment of students. Thank you so much, Dean, sir. I would further like to thank our beloved Vice Principal, Professor Vijay Praneshwaran, sir, Faculty Coordinator Vidya M.N. ma'am for her endurance in arranging this webinar for students. I would also like to thank all the faculties for their presence and support. Last but not the least, all the students for patiently listening and interacting in the session. And I'm sure everybody has learned a lot in today's session. Thank you one and all. Have a nice day.